This podcast is intended for educational purposes only. Advice should be sought about your specific matter. No attorney-client relationship is formed between any client and attorney Don Dennis until there is a signed engagement agreement and payment of an initial deposit. No client-consultant agreement has been formed between any client and Inverted Chaos Incorporated until there is a signed agreement and payment of an initial deposit. What's up, everyone? Welcome to the show. We got attorney Don Dennis back at it again for another court case. Don, thanks for coming on one more time. You got any new information for us? Any new stuff?
Thank you. I appreciate it. And everything I will say is rated R for real and not PG for playing games. I am here with more technology law information, and my goal working with Lewis is to break this down so that whether you wear a white collar, blue collar, or no collar, and as you can see, I have on no collar today, it will be plain and understandable. Today, I'm interested in finding out some of your thoughts, Lewis, on Justin Goldman. And Justin Goldman took a picture of Tom Brady and some other people out in East Hampton, and we're going to talk about it. But the issue is, does embedding a tweet violate copyright law? Mm-hmm. So, because a lot of people do that. Can you, before we even get going, what exactly are we talking about when we're talking about embedding a tweet or embedding something?
Yeah, so typically Twitter, I think, was the first social platform that created this concept where you could get a snippet of HTML code and then paste it onto your website, and it would link to their content and keep it on their servers. The reason that they did this was a way to get brand recognition across many different websites that they had no control over. They basically, it was like a commercial for Twitter, like, hey, look at this piece of content. It's really cool, isn't it? You might want to see more stuff that's over on our website. And that was like the big push for wanting to do stuff like this. Now, YouTube, you can embed a video. I'm not sure what Snapchat can do, but I think you can link to their content somehow. But this seems to be like the normal way of doing going about things when it comes to sharing content on the internet.
Well, that's interesting that you mentioned Snapchat, because this all started on Snapchat.
Oh, really?
What is Snapchat?
Yeah, Snapchat's it started off as a way of taking a picture, and then the picture would disappear in, let's say, 20 seconds, something very quickly. Mm-hmm. So it was like a way of showing something that the people taking the photo thought that would disappear and it would be gone off the internet forever. But that soon changed. It's obviously anything that's on the internet at least once will be able to be copied and duplicated.
Okay.
Yeah.
What happened in this case is that on July 2nd, 2016, Justin Goldman snapped a photograph of Tom Brady, Danny Ainge, and some other people on the streets of East Hampton. And then thereafter, he uploaded the picture to his Snapchat story. So he had a Snapchat account. The photo then went viral. It traveled through several levels of social media platforms, and then finally it made it to Twitter, where it was uploaded by several news agencies. And the news agencies, were online news outlets and blogs who published articles featuring the photo. Mm-hmm. And the key thing that they were talking about was whether or not the Boston Celtics were going to successfully recruit Kevin Durant, and if Tom Brady would help to seal the deal. Mm-hmm. Now, we know Kevin Durant right now, he plays for the Golden State Warriors.
Right.
I believe he was playing for the Was he playing for the Warriors at that time in July 2016?
I wouldn't even presume to know. I think he would play for the Cavs, no? Or is that or the
No, before
Oklahoma?
that, he
What
was
was it?
playing for the Thunder.
Yeah, Oklahoma Thunder. That's what I thought.
I
Yeah.
think he was with the Warriors at that time
Oh, so
because they
he
won
was.
the championship last year.
Hmm.
I don't know, but or maybe he was deciding where he was going to go
Right.
before he went to the Warriors or whatever. So okay, so everybody was trying to get him. He's a real high profile, good
Definitely.
player, handles business.
Hmm.
High scorer, and so Boston wanted to get him. And people just started assuming that that's why they were taking this picture. And I don't know, they wrote all kind of articles. I didn't read the articles, but they wrote a bunch of articles, and they ran with it.
Hmm.
So they embedded these defendants, they copied and saved the photo on their own servers, so that if you read the article, boom, a picture pops up next to the article showing, this picture, the picture of Tom Brady, Danny Ainge, and other people on the street. And then they started talking about it. So here, none of the defendants actually downloaded the photo from Twitter, copied it, or stored it on their own servers. Rather, the defendants only embedded the photo by including necessary embed code in their HTML instructions.
Right.
And then as a result, the defendants' websites included articles about the meeting. And what happened is, a lot of times, and maybe you can explain this, sometimes when you want to go to a photo or something, you have to click a link.
Hmm.
But here, as soon as you got to the article, the picture popped up. What exactly are we talking about here?
Yeah, I mean, sometimes you can go on Google Images and you type in panda or whatever, some innocuous thing, and then it'll show you a whole grid of different images. That's called a thumbnail. If you click on it, it'll pop up and show you a bigger image, and that's like the full size photo. So I think what they're talking about here is as soon as you went to their site, you would see not the thumbnail, the small little image, but like the entire full size detailed photograph, right?
Okay.
Right.
Yeah, full photograph.
Mm-hmm.
So he's suing. Justin's like, forget this, I'm suing you guys because I had a copyright and I'm suing for copyright infringement.
Mm-hmm.
So, okay, what is a copyright? A copyright protects the original works of an author of a fixed work in any tangible medium of expression. So tangible is real. Medium of expression is whether you have it on a billboard, whether you put it on a wall like graffiti, it could be a tattoo, it could be a design, something like that. It's a real way that you've expressed it.
Mm-hmm.
And if you are the author of it, meaning you created it, you have the exclusive rights, meaning no one else has a right unless you give them a license, unless you give them permission,
Mm-hmm.
or unless you sell that work to them to display your work publicly.
Mm-hmm.
Now, this is a pretty complex area of law, so we're going to try to explain it quickly and get to the point.
Right.
But when it says to display it, what they're talking about is showing a copy of it, either directly or indirectly by means of a film, a slide, a television image, or any other device or process. Any other device or process. In this case, we're going to talk about what exactly is a process, right?
Mm-hmm.
Because he embedded the link. So obviously it was displayed, but was it done it wasn't done by film, it wasn't done by slide, it wasn't done by television image. So if you're looking at the law, okay, that knocks all those things out.
Right.
But it says, but what was it done by a device or a process? So now back to display. Display includes a projection of the image on any screen or any surface by any method, transmission, electronic means, or anything else.
Mm-hmm.
So it's important to know that even though the law was written in 76, and back then we didn't have people tweeting, things going viral, things being embedded,
Definitely, yeah.
it said any other means.
Mm-hmm.
Now, let's see here. Let's talk about whether or not we have a process. In this situation, First and foremost, when I read that definition of the copyright law, it did not say that you could be responsible or liable for infringement. In order to be found liable, you have to possess or own the work.
Mm.
So you don't have to possess it. The mere fact that you found a way to display it without permission could make you liable. And now let's get back to the process argument. With respect to the process, here's what the defendants did. So one defendant embedded the tweet, and let's see here. You had to navigate to Twitter. They navigated to Twitter, copied the URL, then used out-of-the-box content management functionality provided by WordPress to embed the tweet within their newspaper article.
Right.
And this was the defendant, Heavy.com. So can you explain what exactly they did?
Yeah, so they went to well, I don't think they detailed like exactly which Twitter profile they went to, right? But essentially it was already run amok on Twitter. People were like linking and copying this image, even though it started on Snapchat and then moved virally to Twitter. Heavy.com went to a Twitter profile somewhere that had been retweeted constantly. And then they took that, they took the embed code, which means Twitter allows them a functionality, a tool set which they can copy a piece of HTML code and then go to their website on heavy.com, paste that HTML code in, and then display the content onto heavy.com without actually downloading or saving that image to their servers, which I think is where the distinction of all of this is happening, right?
Okay. And with the second defendant, the Boston Herald, they pasted a code line into its blog article that contains Twitter HTML instructions.
Right, which is what I was referring to. And WordPress is basically it's called a CMS, a content management system, which it's basically like a blog software. It's think of it like Microsoft Word that you can publish to the internet, like right there, right then. So you're creating an article, and you're pasting in this Twitter code, and that is now displaying that photograph or that piece of content, text and image, that is still being referenced to the Twitter servers.
Okay. And then the other defendant, the Big Lead, they submitted a declaration, meaning they admitted what they said is my entering the URL for the Real Bob Manning tweet into the field for embedded content in the content management system caused this URL to be inserted into embedding code that became part of the HTML code for the Big Lead article.
Right. So as soon as you publish, as soon as you take that embed HTML code and then publish it onto your site, it's now that HTML code is living on your server. So it's kind of intertwined with your stuff, even though originally it was Twitter's code, and it still is, but like now that text is actually living on your server. It's like if they copied save as that HTML page, it would live on your server. So I think that's legally that's what they're talking about, that distinction.
Okay. And then Gannett, the defendant, the vice president for Gannett, said if I wanted that web page to display a photo that a third-party user had posted to a site like Twitter, I could do so without me ever having to make a copy of the photo. I would simply include in my HTML code some additional coding containing a link to the URL of the Twitter page where the photo appeared. So it's more of the same?
Yeah, I mean, it's funny because typically when you're a web developer, if they take that image down, then it's a broken image on your website. So a best practice would be to like save that image and you save it locally. But if you don't own the license or the copyright, whatever, to that image, then you as the internet kind of evolved, it became more less Wild West. You used to have to start figuring out whether you owned these licenses and things like that. But I think that they were like, and then you can also save on web hosting costs by linking directly to that image, so that every single time that image is being hit, you're not being you're not taking that monetary hit by having that image downloaded off your server. So definitely a lot of ways to skin the cat, you know. But I think overall, that's what's going on.
Well, you brought up a very interesting issue. You said you could have saved it locally.
Mm-hmm.
Now, and then you talked about licensing and about having the copyright permission to do so.
Right.
Now, in this case, they were looking for what rule should the court apply to find out whether someone did something that was wrong,
Mm-hmm.
whether the Copyright Act was violated.
Mm-hmm.
So they're in New York, and they're in federal court. There's state courts and there's federal courts.
Right.
Federal courts have their own rules. And each federal court, the ultimate federal court is the Supreme Court, right?
Mm-hmm.
But throughout the country, we have states broken up into districts. So in California, we're in the 9th district.
Mm.
In New York, they're in the 2nd district. New York doesn't have to follow California 9th district law. However, if they don't have a rule on the issue, they may look to 9th Circuit to get some ideas of
right.
what might help them create a law, or they might say, hey, that's a good rule, we'll follow it.
Mm-hmm.
So they looked, and so New York didn't necessarily have a rule on this type of issue, but they found a case kind of similar in the 9th Circuit, which was decided in the western region of the U.S.
Mm-hmm. It
was a case called Perfect 10 versus Google. In that case, what happened was, just to give a little background, is that, let me see here. I'm trying to summarize everything. They were using technology, and the court was looking at, did thumbnail images that automatically pop up when a user types in a search term on Google
mm-hmm.
constitute direct copyright infringement of your right to display something? Second, they looked at the fact that the full images that appear on the screen after a user clicks on a thumbnail constitute direct copyright infringement. So first is, you go on Google, you type in a word, you type in dog, and pictures of dogs pop up. Now, do those little thumbnail pictures of dogs, is that copyright infringement?
Right.
Then if you click the full picture and a full image pops up afterwards that goes somewhere else, is that copyright infringement?
Right.
Two issues. So what the court said is, the thumbnails, when I said the dog, you type in dog, a little picture of a dog, a bunch of dogs pops up, they found those to be infringing because they were stored on Google's server.
Mm-hmm.
So basically what it's saying is, and you correct me if I'm wrong, Google is taking pictures that it found from different places on the internet, saved it on its server. Is that right?
Yeah, that's correct. They're scouring throughout all the internet, and then saving a thumbnail, a small little image, onto their servers. And then when you click on that and you're like view full size or something like that, then that actually takes you to the actual full size image, but it's also no longer on Google servers. It's on the server that it was originally put on.
So what the court said is that when you take, and so Google may not own those little pictures that they're using to put on the thumbnail, right?
Mm-hmm. Yeah, correct.
So when you do your search and those pictures pop up and you're on Google's server, the court said Google was infringing on someone else's copyright because they took pictures without permission, without a license, things of that nature. But the court also said that the full images, which were stored on a third-party server and accessed by inline linking, and they said it's kind of like embedding, was not infringement. And so this is the server test that they were looking at from the 9th Circuit. And they said the issue is whether a website publisher is directly liable for copyright infringement is going to be based on whether the image is hosted on the publisher's own server or is embedded or linked from a third-party server. Does that make sense to you?
Yeah. So inline linking, what that means is whenever you see like a little an underlined blue, typically it's like a blue link, and it's got a little underline on it. You click on that. It's got the, like the cursor looks like this. You click on that, and it takes you to another website. What they're talking about is when they're referencing that the website address, they're referencing the actual server. Just to reiterate that one more time, the original location of that image. It's no longer referencing google.com. It would be like, mydogwebsite.com, and then now that's going to that server, which is, I think, what they're talking about in terms of when the thumbnail is living on Google, they are they don't have the license for that image, but then once it links directly to that website, it's no longer living on Google server, so they're not liable, correct? At least in terms of this ruling, this court case.
Yeah. So, but okay, and so back to when we went through earlier, we went through what each defendant did in order to get the pictures for their articles, right?
Right.
So what the court said is the fact that each took active steps to go through, grab that HTML, insert that code, they engaged in a process that resulted in the transmission of photos so that they could be shown. So therefore, in terms of the Copyright Act, they have satisfied that requirement that it be a process. And the court said that this is a lot different than that server test we just discussed in the Ninth Circuit. The court said in that case, the one we just went over, Google's search engine provided a service whereby a user navigated from one web page, the first one that you just discussed, where the thumbnails pop up, to the actual web page. Whereas in this case, if you wanted to read the article by the Boston Herald or by the Gannett or by Heavy.com, as soon as you clicked on the article, the picture was there.
Right.
So then so you didn't have to go somewhere else. And they didn't. And again, they said the plaintiff owned the rights to the picture, so therefore he didn't give them the right to use it. So that it's likely that there was some infringement that took place.
Yeah. Right.
So at this point, this case has not been decided. This case was filed by the plaintiff. He's suing for infringement against all these different agencies. And then, what happens in court cases oftentimes is someone will sue someone, which the plaintiff will sue a defendant for what they feel is a violation of their legal right. And the defendant will say, you know what, even if everything you said is true, it's not a violation of the law. So for example, if Paulie, the plaintiff, sues Daryl, the defendant, because he said that Daryl came to his house at 11 o'clock at night and rang the doorbell and ran out of the yard, is that in fact a violation of the law? Yes, it might have woke him up. Yes, it was annoying, and he could sue him for, make up something and sue him for $1 million.
Sure. Yeah.
And so Daryl will go to court, or the defendant will go to court. They'll go to court, and before they even have a trial, they'll file a motion for summary judgment, which says, assuming everything he says is true, I didn't violate the law because there's no law against ringing the doorbell at 11 o'clock at night. And the court will look, and if they don't find a law to back up the claim, they'll say there's no case, and the case is thrown out. And however, if they say, well, no, we found a law and you have violated, they'll allow the case to proceed, which will be on path to go to trial. And so you're going to have to keep paying attorneys, you have to keep paying court costs, keep going through the motions, and it's going to make the case more and more expensive. And so sometimes people, if it gets past, so for example, let's say he was suing for $1 million, and the court says, nah, I think something was done wrong here. Then the defendant may say, well, look, do I really want to take a chance of going to trial and being found guilty for $1 million or even more? Or do I want to say, hey, I'll offer you $500,000. Let's just go our separate ways and shake hands.
Right.
And in this case, the court said, we're not going to dismiss this case. We think it might be copyright infringement, so we're going to allow it to go forward. So it increased the bargaining power and the settlement value of this case at this point. So that's why motions for summary judgment are so important, because a lot of cases end at this point.
Right.
So, but however, the court says, so there are some issues, And one of the things that they said is, how it may be copyright infringement. However, it may be a possibility that the photo was already in the public domain,
Mm,
and he posted it for everyone to see.
right.
So was he really trying to safeguard it and sell it to different people and only allow different people to see and use it? Because isn't it true everybody kind of reposts things all the time?
Definitely, yeah. That's part of the internet. That's the deal.
So one of the things that the defendant said is if they lose this case, the news agencies are saying if they lose this case and they're found liable for copyright infringement, this could have a chilling effect on the way the whole internet works.
Yeah,
What's about that?
yeah. I mean, this the whole the origin of the internet came about with essentially scientists sharing research papers back in the 60s, and it was open and free. That was the whole concept of it. And like if you write an article, you want other people to read it, so you want people to just to link to your and cross reference and things like that. So if you start to clamp this down, then I don't want to link to this because I could be held liable, then it's just going to silo all of these, like the internet's like interconnected nature is it's gonna basically go away. So I agree. I think this is gonna this could have a detrimental it could be pretty bad in the future.
Another issue is, as I was saying, this was decided in New York. So unless this case is appealed, then this is going to be law in New York, unless this case is overturned.
Mm-hmm.
So therefore, if I operate a business in California, we talked about had that server test.
Mm-hmm.
In New York, operates a different way. Then what kind of implications does that pose for companies that have a website presence if you're trying to find out what you're doing will be okay in New York and in California? Because if you operate on a national or international basis, you could be sued. Someone could say, well, you know what? I'm not going to sue in California. I feel you used my copyright. I feel you've violated my copyright. So I'm going to sue you for copyright infringement. But I don't like the way the law is lining up in California, so I want to try to sue in New York. Because technically, let's say I'm a New York citizen, or let's say, it just makes more sense. I have more of an opportunity or probability of winning since this case went forward. So then how, it creates issues as to which test are you going to follow in terms of a business. And so this right here, in my mind, makes me think that business owners, it would behoove them to reach out to an attorney that's knowledgeable in this area to help guide them as to how they're going to set up things on their website, how they're going to post things, articles, or whatever else you're trying to sell as your services, because you don't want to be doing okay in one state and then get sued in another state.
Yeah, definitely.
And then also, this reinforces the idea of making sure you have a consultant, someone that's knowledgeable in technology like Lewis, that can guide you on how to make sure you put the proper technological steps so that you do what's right, and they're not going through this analysis of what exactly you did in a court case,
right?
And then it ends up finding you liable when you could have prevented this all from the jump street.
Definitely.
So just the fact that you meet an attorney and they say, "Hey, I know copyright law." If they're not up to date on the technology and on the internet aspect of it, how is it going to help you? The same way you find a graphic artist or someone in the space in which Lewis operates, and they say, "I know how to do all this and that," and then they do it, and then you get letters about cease and desist, or you get lawsuits showing up, and then you come to find out, what that person did, they didn't know the same way that Lewis knows. Then you're stuck again on Gilligan's Island.
Yeah, exactly.
So, these are things to really make sure that when you're dealing with someone, you're not just hiring them based on a nice suit, a nice outfit, or a plaque on the wall, as opposed to you thoroughly investigate their knowledge as to what you're getting into, so you know what you're getting into before you get into it.
Well said. So I do have something to talk about in terms of this court case. If they had saved this photo to their servers, they would have, in order to go, like how you're saying, go through the proper channels, they would have had, let's say it's on Getty Images or like some sort of photo licensing service. They would have had to make sure that they own the license to this image in order to publish it onto their site. But then since they embedded it through Twitter, then now this is kind of like this new Wild Wild West where it's like, well, I never saved it to my servers, therefore I don't need to own the license to it. And now that's where it gets a little murky. Where to me it seems very straight cut in terms of like, if you're showing this on your server, I mean on your website, make sure that you do have the license for it. But since you're embedding it, then that's where it gets murky, right? So that's
Yeah, well, so far that's what it's saying, but again, it depends on what region of the country you're in.
mm,
And then second of all, it depends on what if you had a license, what does the license allow you to do with it?
right.
And so that's where it gets in again, where you need to make sure you have an attorney that can guide you through all that, because I've seen licenses where you have the right to use something as much as you want. But then if you want to make money off of it, there's a problem.
Right.
Or if you're not, paying them some of your royalties from what you're paid, there's an issue.
Mm-hmm.
You can use it in certain platforms and you can't use it in others. So all of these things can be negotiated. However, and then the length of the license and what states you can use it. Is it global? Is it domestic? Meaning you can only use it in the US or you can use it international. All of those things are important to know about also. So that's where instead of, you can get into splitting hairs, but a lot of people, they'll say, oh, I'm gonna buy a license. And then they go buy the license.
Right.
And then later the devil's in the details and they start the devil starts showing it, rearing his ugly head, showing you his tail and everything. And then you get bitten laughing at you. And so you spent money and you didn't even get exactly what you want. So it's kind of like going to a car lot and thinking you're buying a convertible and all you have is a sunroof that only goes halfway or it's a pop-up.
Yeah. So how do news agencies get around, or like, do they actually have to purchase or get a license for every piece of content that they report on?
Well, according to this case, unless they're linking somewhere else, unless you're going to click a link and go somewhere else, they better have a license.
Mm-hmm. Okay.
And I think that kind of comports with the California case. Unless you're linking somewhere else, you need some kind of license.
Right. So this seems like people would be less and less enthusiastic about reporting or showing things because of the complex nature of like image or media licensing, and maybe they might just want to talk about it versus showing the actual photo if they were referencing or talking about reporting on an image that they were looking to report on. Right?
Well, not necessarily. It is. I agree with you. It's a very complex issue, and in fact, one of the defenses. I'm going to answer your question. One of the defenses to copyright infringement is fair use, meaning that you've been accused of copyright infringement. However, you're not liable because fair use. You used it like when you watch the news at night and they have little videos they show or little news clips. You're using it for commentary, for news, for parody, like on Saturday Night Live or another comedy show.
Right.
Things of that nature. That's fair use. Or you took it and you transformed it. So, for example, if someone has a picture up and they sell the picture, but you're using it for a non-commercial purpose, that could be found to be fair use if you're not messing or damaging their market value,
right?
Or things of that nature. But what the Supreme Court said, but in order to assert fair use, you first have to be accused of copyright infringement, and most likely you're being sued, and most likely you're in court paying attorney fees and defending yourself before you get to your motion for summary judgment to assert fair use. So you may spend $150,000, $200,000 to defend yourself just to find out you were right, and you might not most likely get any of your money back.
Right.
It's the same. So analogy would be some two guys get into a fight at a bar. One guy attacks another guy. The guy, in defending himself, kills the guy.
Mm-hmm.
So first and foremost, the police are going to arrive, and you are going to be charged with murder. Now, you will have to hire an attorney, most likely, unless you're going to use a public defender. You may be deprived of your freedom. You may have to put up money for bail and go through the whole process. And at the end of the day, they'll say, yes, you are not guilty because of self-defense. However, the court's not going to give you a refund for your defense attorney.
Right.
So you had to go through this whole process. So what most companies should do, and also what the court said with respect to Supreme Court with copyright and fair use, is that this is one of the most complex areas of law. So in answering your question as to what companies, news agencies, people should do, is sit down with an attorney knowledgeable in copyright, trademark, the various intellectual property issues, and the internet, and have a discussion as to how they plan to market their services. If you have goods, how you plan to market your goods. Is it domestic? Is it international? And make sure that that attorney knows the entire context and landscape of what you're doing. And then once you identify that, look to make sure that you're safeguarded and protected on all aspects of your business before you move forward. Rather than, you have to be very careful when you ask the questions, especially with these new types of things, being that the law is still developing. You don't want to just say, hey, get me a copyright, give me permission. You want to make sure you explain everything that's going on so that there's other potential loopholes or other potential gaps in your coverage that you're protected.
Mm-hmm. So it seems to me like what I see in the future is every single time you take a photo on your mobile phone and then upload it to Twitter or Facebook, any social media platform, they're gonna ask, and this is purely conjecture, but yeah. I feel like they're gonna ask, what type of media licensing are you willing to impart? So can someone else retweet this? Can you allow someone to embed this onto other third-party websites?
If I had to guess, I don't even think they're going to ask. I think they're going to make it a part of their terms and conditions of use, saying you agree to allow.
So like they're already so every single time you would upload, they would make that decision for you.
Probably, if you want to use their service.
Mm-hmm. Yeah, that makes sense, because then everybody is covering their butt.
Yeah,
that's interesting. Let's see here. Is there any other details on the case, or is?
No, I think we've covered it in detail. Yeah. Broken it down. I think people can kind of get a context as to what's going on and how much chaos there is in this chaos.
Yeah, definitely. Great. I feel like if there's any other updates to the case, we'll definitely report on it in the future. Definitely, another case that I feel like might change the way we go about the internet in the future, right? So
definitely.
Yeah. Thanks for bringing this up with us. I really appreciate it.
No problem. And this case was just decided February 15th, 2018.
Mm-hmm. It's pretty recent.
Well, not decided, but this motion was just ruled on February.
Right.
This opinion was just issued in order on February the 15th. So this is hot off the press.
Definitely. Great. Thanks yet again, Don. If you have give us your social and your website stuff, so if anybody wants to reach you, they may do so.
If you're interested in reaching out, if you need legal services in the area of intellectual property or internet law, feel free to contact me at www.dennis.law.com or at 213-455-0880 and on Instagram at Attorney Don Dennis.
Thanks, Don. And if you want to listen to more episodes about this or other topics in general relating to entrepreneurship, design, please subscribe to the Inverted Chaos podcast, like and subscribe, that whole deal. And we appreciate you listening. Thanks for your time.
Yeah, and make sure you share this with anyone else that you think could benefit.
Definitely. Thanks, Don. We'll see you. We'll see you soon.
See you.
All right. Bye-bye.